So, what happens when the person you love asks you to risk everything for their dream? It's a tough spot to be in. Today, we're going to dive into a really important legal case that created a crucial safety net for exactly those moments. When love, money, and your home are all on the line.
I mean, it's a powerful question, right? Because it gets right to the heart of a dilemma so many of us could face. You trust someone completely, they ask you to help them chase a dream. But what if that help means putting your own financial security, your future, on the line? And let's be real, for most of us, our home is the single biggest asset we will ever own. It's so much more than just bricks and mortar, right? It's your security, it's family, it's memories, and you better believe it's the very first thing a bank looks at when they're thinking about collateral. Okay, so now let's bring in the dream. Imagine your partner has this brilliant idea for a new business. It's their passion, their one big shot. But, like any new venture, it needs cash to get started, a pretty significant loan to get it off the ground. So the bank is willing to play ball, but they see this new business as a risk. And to secure that loan, they need a guarantee, some kind of security to fall back on if the business doesn't make it. And wouldn't you know it, they've got their eye on your most valuable asset, your home.
And this is where it all comes to a head. The loan documents are right there on the table. Your partner is looking at you, counting on you. And all that stands between their dream and reality is your signature on that dotted line. A signature that legally ties your home to the fate of their business. Talk about an impossible position to be in. But here's the good news. Thankfully, the law actually recognizes this exact kind of high-pressure situation. And this brings us to a really crucial legal idea, one that's designed to protect people when one person's will might be, well, totally overwhelmed by another's. It's a concept called undue influence.
So what is it exactly? Well, undue influence isn't about, obvious threats or anything like that. It's much more subtle. It's when a relationship of trust, that deep confidence you have in someone, is used to persuade you into a deal that's just not in your best interest. The key here is that your consent isn't genuine because it wasn't freely given.
Now, the law actually splits this into two types. First, you've got actual undue influence. Think really clear threats or bullying, stuff that's honestly really hard to prove. But then there's the real game changer, presumed undue influence. See, with this one, the court doesn't need direct proof of pressure. It can just infer it was there, simply because of the relationship and the type of deal it is. A wife guaranteeing her husband's huge business loan with their shared home? Yeah, that is a classic example of a transaction that legally calls for an explanation. And this exact issue, this idea of presumed influence, came to a massive head back in 2001. We're talking about a landmark case that went all the way to the UK's highest court. It's known as the Ettridge case, and believe me, it completely changed the rulebook for banks in these situations. And this is what's so wild. It really shows you the scale of the problem. The court wasn't just looking at one little dispute. No, they bundled 8 separate cases together, and the pattern was identical, every single time. A wife guarantees her husband's business debt, she uses the family home as security, the business fails, and the bank comes knocking to repossess the house. And in every single one of these cases, the wives argued that they either didn't fully get what they were signing, or they just felt like they had no other choice. So this led the court to a really fundamental question. At what point should a bank, this huge, powerful financial institution, realize that, hey, something might be off here? When are they officially put on notice that a signature might not have been freely given? And more importantly, once they have that suspicion, what's their responsibility to protect the person who's in the more vulnerable position? Well, the court's answer was pretty brilliant, actually. They essentially created a brand new rulebook for the banks. They laid out a really clear, practical set of steps that lenders now have to follow to make sure the person giving the guarantee truly understands what they're getting themselves into. And this became known as the Ettridge Protocol. This protocol basically builds a wall of protection, and it works in 4 really clear steps. Okay, step 1, the bank is automatically put on inquiry anytime a person guarantees a loan for their partner that isn't for their joint benefit. It's like an automatic red flag. Step 2, the bank has to stop everything and insist that the person guaranteeing the loan, the surety, gets independent legal advice. Step 3, to make sure that advice is actually useful, the bank has to give the lawyer all the key financial details about the loan. And finally, the 4th and most crucial step, the bank has to get written confirmation back from that lawyer saying, yep, I've explained all the risks and they understand. So the bottom line here is this protocol isn't just a friendly suggestion. It's mandatory. It's a process.
What it does is it sticks an independent, legally qualified person right in the middle of the transaction. And their only job is to look out for the interests of the person who's about to put their home on the line. It's a formal, powerful safeguard against pressure and misunderstanding. So you might be thinking, okay, this case happened over 2 decades ago. Why does it still matter so much today? Well, it's because it established powerful, clearly defined financial rights that protect you right here, right now. There's this amazing quote from Lord Nichols, one of the judges on the case, that just sums it all up perfectly. He said, "It's not enough for you to just sign a piece of paper. The bank has to take reasonable steps to make sure the risks have been brought home to you in a meaningful way." See that phrase, in a meaningful way? The whole point is genuine, real-world understanding, not just ticking a box. So let's boil it all down. What does this actually mean for you? Well, first, you have a right to independent legal advice. Second, that advice has to be private. Your partner cannot be in the room. Third, the lawyer's job is to explain the risks in plain, simple language, like what really happens if this business fails. Could you actually lose your home? And fourth, the banks have a duty to make sure your consent is informed and freely given. And maybe most importantly, remember, this isn't just for married couples. It applies to any relationship where there's that special mix of trust and confidence.
And that really brings us to the final crucial point. The Eatridge case created this incredible safety net, but it doesn't make the decision for you. What it does is make sure you have all the information you need to make it for yourself. So before you ever put a signature on that line, you have to ask yourself, who are you really trusting? Are you trusting your partner? Are you trusting the bank? Or are you trusting your own fully informed judgment?